The Haldane Society of Socialist Lawyers. We are halfway through our lecture series for 2013-2014, and we're very pleased indeed that this is a lecture on squatting, the government's assault on squatters. But I have to say that was probably a bit kind about the opposition party, because of course the opposition party is also joining in the assault on squatters. Just a couple of words about the Haldane Society. My name is Liz Davis. I'm chair of the Haldane Society. We are the Haldane Society of Socialist Lawyers, and we regard that title as utterly self-explanatory. Mainly, we're mainly lawyers, law students, paralegals, people who are involved in studying, practicing or teaching law. But we're not exclusive about that. We're very happy to welcome into membership anyone who has an interest broadly in legal and political issues. We are much clearer, however, that we are socialists. The Haldane Society has been around since about 1929 or 1930. We don't know exactly when, because all our records were blown up in a bomb in the Second World War. But roughly 1929, 1930. It's always called itself socialist, and we're not going to change now. We very much hope that, having heard this lecture, if you're not already a member, that you will be inspired to join us. There are membership forms there, or you can join through our website, which is www.haldane.org. What do? We do a number of things. First of all, we do put on this series of lectures every year between the autumn and the spring, primarily for law students, but also for Haldane members and any other lawyers and practitioners. We are very heavily involved in campaigning, and it won't surprise you that over the last year we've been extremely involved in the campaigns to save legal aid, defend legal aid. Our view is that legal aid should not only be defended but actually extended, that already it has been cut to the bare bone, and that people are prevented from accessing justice as a result of those cuts. But obviously that's not a view that finds favour with the government, and that the government, at the moment, are proposing very extensive cuts to legal aid indeed, which, if they do go through, and a number of them have already gone through, means that criminal defence will be conducted at a very low level, and as far as civil legal aid is concerned, there's a real possibility that people will simply not be assisted to have access to the civil court. So we've been involved in the Justice Alliance and the other campaigns around Save Legal Aid. We're also involved in anti-austerity campaigns. We've been campaigning against the bedroom tax, other cuts to welfare benefits, cuts to public services, and so forth. And we're regularly involved, principally with our colleagues in Campaign Against Criminalising Communities, around campaigns to defend and again extend civil liberties. So those tend to be the main areas of our campaigning work, and we also have international links with lawyers and human rights defenders around the globe. We also provide what we consider to be, what we hope is a very valuable service, in that we provide legal observers at demonstrations, often the small demonstrations that don't receive a lot of publicity, as a result don't necessarily receive a lot of media scrutiny, particularly around the actions of the police. But when requested by demonstration organisers, then we will try and put together volunteers who can go and be legal observers on demonstrations in order to ensure the accountability of the police and to scrutinise police behaviour. We have a list of volunteers who are prepared to be legal observers. Even if you're not convinced to join the Haldane Society, of course we hope you will be, then maybe do think about becoming a legal observer or putting your name on the list. Putting your name on the list doesn't commit you to anything. It simply means that the next time we get a request for legal observers, we'll send a request round and we will ask if anybody can help, but absolutely no commitment, you don't have to. And we do provide training. We don't send you out there untrained. We provide training and support. We also publish 3 times a year our excellent publication, Socialist Lawyer. The current issue is over there. It was published in October, and the next one will be coming out in February. It costs £3, but if you join the Haldane Society, then it comes through your letterbox 3 times a year free. If you're interested in joining, then please do take a copy, and you can also join by filling in a form in Socialist Lawyer. I said that we do these lectures. I'm about to introduce David and Mike, but let me just mention the lecture that's coming up in a month's time. We're very pleased that we have Phil Shiner, solicitor with public interest lawyers, who is going to be giving us a talk on the human rights violations by UK troops in Iraq and in Afghanistan. And you've probably seen in the newspapers in the last couple of days that Phil Shiner, who's had an absolutely brilliant record of representing Iraqi citizens who have been trying to claim redress for the abuse that was meted out to them by British troops, notably the family of Baha Musa, who was murdered whilst he was detained by British troops, and a number of the people who were also arrested and detained by the troops with him. And Phil Shiner has spent the last 10 or 12 years indefatigably litigating to confirm that the Human Rights Act extends to the actions of those troops, to try and obtain redress for Iraqi civilians, and he has just submitted a complaint to the International Criminal Court accusing the various ministers of defence and under-secretaries of state for the armed forces and senior military figures of war crime for their failure, their complicity in the abuse that was meted out both to Iraqi and Afghan citizens. So we're very excited that he will be talking to us about that in a month's time on the 13th of February. And our final lecture, we haven't confirmed the topic or the speaker yet, but just for your diary, will be on the 13th of March. And you can get all information about all of those events on our website. They're all held in this university, not normally in this room, because it's a bit big for us, usually over in the other building up on the first floor, but keep an eye on the website. As I say, tonight's lecture is on the government's assault on squatters. We saw the beginnings of the assault with the Legal Aid Sentencing and Punishment of Offenders Act, which criminalised for the first time anybody who was squatting in a residential property. And the legal implications of that, as well as the political implications, are still really reverberating. But of course it's only just been laid to rest, and there are already calls for extending that criminalisation to squatters who are squatting in non-residential properties where nobody can make a case that somehow home occupiers have been displaced from their homes. And we know that David and Mike will tell us more about that. David Watkinson is our first speaker. He is one of the vice presidents of the Haldane Society. He's a retired barrister, spent over 40 years practicing exclusively in housing law, with a particular emphasis actually on squatters' rights. And I don't know whether he's going to tell you the story. If he is, I'm about to steal his thunder, but one of his best stories is that he starts pupillage. His pupil supervisor was representing squatters, and David was sent along as a pupil barrister, to go and talk to these squatters, found himself so inspired that he ends up squatting himself 40 years ago. Really, that was the beginning of his career. If you, like me, are a bit of a housing law obsessive, and you go through back volumes of the housing law reports, you will find David's name appearing in nearly every case, or in every other case. It is amazing how often he comes up. He doesn't always win, because he's appearing for the occupiers, for squatters, for tenants, sometimes for homeowners, and of course the law, on the basis that the law upholds property rights, is very much against those rights, and in many cases David did lose. But losing legally doesn't always mean that you lose politically. In a number of those cases that were lost at a higher level, the law then got changed at a political level through Parliament. I asked David a few minutes ago what he's proudest of in his career, and he mentioned a case called Kay in the UK that was a decision of the European Court of Human Rights. Mr. Kay was somebody who had been in short life housing operated by Lambeth for about 30 years, something like that. Started off as short life and became long life. Technically he had no remedy in domestic law, and David insisted that Article 8 of the of the European Convention was relevant, that the right to respect for your home was a relevant consideration when the court's considering whether or not to make a possession order against someone who has no formal property rights. That was an argument that started to be run by a number of lawyers when the Human Rights Act came into force, and was considered by the House of Lords a number of times and received very short shrift. And it was David's persistence and Mr. Kay's persistence that ended up with the decision of Kay in the UK in Strasbourg, which held that Article 8 was relevant, and as a result that has made really something of a difference for a lot of occupiers who otherwise would have turned up in court and simply been told by the judge that the judge was very, very sorry for them, but there was no property rights. They had no property rights to the land, and that was that. The landowner just won. As a result of Kay in the UK, the occupier is entitled to ask the court to look at his or her personal circumstances and any other relevant facts in the decision to come to possession. And so David and all of us are very proud indeed of that case. But probably there's something else that David should be prouder of, which is less high profile, but David spent 40 years not just taking the big important cases to Strasbourg and the House of Lords and the Court of Appeal, but going to the county courts and the magistrates' courts and using all the legal arguments that were available to try and keep people in their homes. And most of the time he was successful, and so they didn't become big important reported cases because he'd won at first instance. And doing that makes a real difference to people on a daily basis. It actually, if you keep somebody in their home, it makes a real difference to the quality of their life. And I think it's fair to say that those of us who admire David are not just proud of his record in establishing human rights, but we're also proud of his persistence in continuing to represent occupiers at any level of the court and actually trying to make sure that they have the right to stay in their home. David will speak first. Let me say a couple of words about Mike. Mike is representing the Advisory Service for Squatters, ASS, which has a venerable history, again nearly 40 years, of providing advice to the squatters movement. Its publication, the Squatters Handbook, is very well known and well used by anyone involved in squatting. I don't know whether it's used by the other side as well, so they know what advice is being given to squatters. It's difficult to keep it up to date because, of course, the law keeps changing and there keeps being threats of the law changing even more so. So at the moment it is out of date, but it is certainly a tool that nearly every squatter knows about and uses. So Mike, when David is finished, will say something about what's happening on the ground with the criminalisation of squatters, and I think tell us a few stories about what has been happening and so forth, as well as looking to the future and what the government or the Labour Party might be doing. We're very sorry that we don't have CPD points. For those of you who are practitioners, as I understand it, you can still claim a number of CPD points, just not your full 12, from non-accredited lectures, so this still counts for non-accredited, but we don't have forms for you to fill in. We are also recording the talk. As you will see, those of us at the front are being filmed by that computer there. None of you will be filmed. We're not going to turn it round to film the audience, but if you ask a question, then your voice will be recorded. If you don't want that to happen, then please just say so and we'll switch it off and switch it back on again when you've finished your question. And the recording will then be available on the Haldane website for anybody to see. And finally, can I ask you to turn off all your mobiles, or at least put them onto silent? We will ask, David will speak for about 20 minutes, Mike for about the same, and then we'll have a general questions, discussions and so forth, probably finish at about 8 o'clock. Okay, thank you very much. David.
Thank you very much, Liz. If you have any trouble hearing me, please give a wave. And have you got this handout? Looks like this. If you haven't, then there are some down at the front here. In fact, I think at least 3 people haven't got them, and they're over on that side. Thank you. Well, while Liz is taking those up, thank you for your kind words. I would like to add 3 things I thought of while you were speaking. That is, my other area of practice was gypsy and traveller law. And the way I got into that was because it was the same proceedings that were used to evict gypsies and travellers as was used to evict squatters. The next is Mr. K. Mr. K, in fact, was one of several hundred people who was occupying residential property in Lambeth. So he represented a mass occupation, and the result in his case affected other cases as well as his own. And at last, since just to say, it's not only Liz who refers to me as persistent. I was appearing in a High Court homelessness case once, and after I said my bit, the judge turned to my learned friend and said, "Now," he said, "you've got a problem in this case, and your problem is your opponent is Mr. Watkinson, and Mr. Watkinson is persistent." So I guess I won that stage of the case. Now, to the topic. The government's attack on squatters. So the focus is on section 144 of the Legal Aid, Sentencing and Punishment of Offenders Act 2012, LASPO. We thought it was bad enough when that was enacted. Little did we know what was coming. But to do with criminal trespass. The creation of section 144 is in its way an example of how, and perhaps why, oppressive legislation can be enacted. I'm also going to look at the aftermath of the enactment and some comment on the future. But I'm very glad that Mike from ASS is here. There may be squash representatives here as well, because they are able to say better than I what has been happening on the ground since the enactment. But first, I'm going to take you on a historical journey because I think it's important to get the background and to see that measures against squatters are not new. Indeed, they started almost as soon as the current wave began in the late 1960s. And here I'm going to introduce you to this book, Squatting, the Real Story, published in 1980 by the Bayleaf Press. Edited by Nick Waits and Christian Wolmar, who later became famous as a commentator and writer on railway trains and transport. This, I think, is the only book the Bayleaf Press ever produced. But apart from the chapter written by myself, it is a book which will tell you really what it was like for the squatting movement on the ground from the 1960s up to 1980. And the handout that I've given contains extracts from the book. And if you just turn over the front page, you get page 11, which sets out various reactions to squatting. Now, squatting arouses enormous passion amongst those involved in it. It also involves media interest, the drum of the hat. You'll get the media around on a squatting issue, despite, and I was a bit surprised by it, always the relative low and localised level of the occurrence of squatting. But there you've got set out the reactions for and against. What leads to squatting? Homelessness and the existence of empty dwellings leads to squatting. Can I ask you to turn over the next page? And you'll come to a set of slogans on walls that date from the 1970s. Now, just below the middle, below one of my favourite slogans, "Squat now while stocks last," you'll see thousands of houses empty, thousands of houses empty, thousands on council lists. We have nowhere else to go. No eviction, houses for all. And although squatters have not always been passive, they have been the focus of anti-eviction campaigns. Members have initiated campaigns against changes in the law. If you turn over to the next page, you'll see various examples of that. Squatters Conference at the bottom, Robinson Crusoe, on his own, like Charteris Road squatters, defend the Tolmers 81, that's Tolmers Square on Euston, a reference to the campaign against the criminal trespass law public meeting. Go over the page, you get more political posters. Who gains from criminal trespass law? Workers can save their jobs by occupying. The criminal trespass law would put them in jail. Stop the criminal trespass law. I'll be coming on to what's being referred to there. And of course, no movement can be without a picture of a demonstration in front of the High Court. So you've got it on that page on the left-hand side. If you turn over the page, you come to the demonstration, the campaign against the criminal trespass law. Occupy factories, not jails, is one of the slogans. And that is the page before a chapter on the erosion of squatters' rights, which was written by your speaker. Where I'm going to start now with the history is how is a squatter defined in law, and the definition comes from the case of MacPhail and Persons Unknown in 1973, and it's given by Lord Denning, the then Master of the Rolls. And he says, what is a squatter? He is one who without any colour of right enters on an unoccupied house or land, intending to stay there as long as he can. He may seek to justify or excuse his conduct. He may say that he was homeless and that this house or land was standing empty, doing nothing. But this plea is of no avail in law. So let's start in 1969. The first major publicised squat took place then, when homeless families occupied empty public housing in the area of the London Borough of Redbridge. And the squatters challenged evictions without a court order by council bailiffs, relying on the Forcible Entry Act 1381. In 1969 also, the High Court ruled that an order for possession made against trespassers, that an order for possession could not be made against trespassers who were not named as parties, nor attended the proceedings to be named as parties. That was a Brighton case. But in 1970, the Rules Committee created a special procedure for the eviction of trespassers. They were included in the rules of Supreme Court, Order 113, and in the County Court rules of Order 26. And they are now part of the Civil Procedure Rules, CPR 55. And the rules provided at that stage that owner was entitled to a possession order against trespassers known or unknown. He first had to take reasonable steps to identify the occupiers, but he could obtain a possession order on 7 days' notice, which was an advance, and less in cases of urgency. In 1973, in the case of MacPhail and Persons Unknown, the Court of Appeal ruled that the Forcible Entry Acts did not protect squatters. That was in a case in which the main argument was about whether the court had power to suspend a possession order against squatters. The court ruled that it did not, but in the course of that, made this ruling on the Forcible Entry Act as well. Which is a common experience of practicing lawyers, is that you find the court ruling on an issue which you hadn't raised and wasn't the main subject matter of the case, because it chooses to do so, and not in your favour. 1974, the Law Commission produced a working paper which proposed a criminal trespass offence and the repeal of the Forcible Entry Acts. And there it is, a 1974 Law Commission's working paper, Criminal Law, Offences of Entering and Remaining on Property. And in that working paper, the Law Commission proposed a criminal trespass offence like this, that it would be an offence if the trespasser failed to leave as soon as reasonably practicable after being ordered to do so by a person entitled to occupation. And this was proposed to include all land, not just residential land. So there was a campaign, the campaign against the criminal trespass law, which brought together trade unionists, students and squatters in opposition to those proposals. In 1976, the Law Commission produced its final report, and that proposed 5 offences involving trespass, as well as the repeal of the Forcible Entry Acts. And those were using or threatening violence to secure entry, knowing that there is someone present opposed to the entry, being on premises as a trespasser and failing to leave after having been required to do so by a displaced residential occupier or a protected intending occupier. Then I'll just run through the others quickly because they turn out to be less important. Trespassing with a weapon of offence, trespassing on embassy or consular property, and resisting or obstructing a bailiff or sheriff executing a possession order. Now, those proposals eventually became law in the Criminal Law Act 1977, sections 6 to 10, and that's where they remain. There's 2 points about them. First of all, the violent entry offence could be used by squatters because it was an offence for an owner or any person to force entry when someone else was present on the property. Secondly, the lawful occupier or someone who had been granted the right to occupy was protected by the displaced residential occupier DRO, protected intending occupier PIO provision. And the persons protected were owners, leaseholders, tenants or licensees whose status had been verified by a justice of the peace or by the local authority landlord. Just before the enactment of the Criminal Law Act in 1975, there were Court of Appeal and High Court rulings that the reasonable steps defence were technical defences only, and the court could hold that even though reasonable steps had not been carried out to identify the occupiers, the court could still make a possession order. And in 1977, the Rules Committee removed the reasonable steps requirement altogether. 1994, the Criminal Justice and Public Order Act of that year introduced the offence of failing to leave within 24 hours of being served with an interim possession order. And there was an associated procedure in the civil courts whereby an owner or person entitled to possession could obtain an interim possession order on certain conditions, and then it would become a criminal offence for failing to leave on service of the interim possession order, or IPO. Same Act also provided that a DRO or PIO, you know what I'm referring to when I'm referring to those, could use force to enter property and evict the squatters. Now, in Squatting a Real Story, I concluded my article by writing, "The law has not treated squatters as a class of person deserving any rights in law, but rather as a problem against which measures must be taken. The limited amount of toleration allowed them by the law has been removed piece by piece. New criminal offences have been created to put further pressure on them. Although trespass is still not a criminal offence, steps have been taken in that direction. Squatters are being moved from the position of individuals in dispute with landlords over possession of property to that of criminals liable to have the penal machinery of the state used against them." Well, I don't often claim to be a prophet, but I was prophetic when I was writing that. On the 13th of July 2011, the Ministry of Justice issued a consultation paper, Options for Dealing with Squatters. So now we're getting right on to the topic of this meeting. That consultation process ended on the 5th of October of 2011. The consultation paper put 5 options for dealing with squatters, ranging from the creation of a new offence to doing nothing. On the 26th of October 2011, i.e. about 3 weeks after the consultation process had ended, the government published its response to the consultation submissions that it had received. And it announced its decision to introduce a new offence, a new criminal offence, and that was introduced into the Legal Aid Sentencing and Prevention of Offences bill that was then proceeding through Parliament. And it was introduced at the end of October 2011. So that was a pretty rapid process. There was a campaign, quite a high-profile campaign, in fact, spearheaded by Squatters Action for Secure Homes, both before the government response and during the parliamentary process. But the new criminal offence was enacted pretty much as proposed. I'm going to make 2 points, just 2 points, about the process leading to the new offence. First, the government public position was that change was necessary to protect people from squatters occupying their homes in their absence. That was misleading. The DRO, PIO provisions already existed and provided that protection. Evidence of such as that happening, squatters occupying people's homes in their absence, was hard to find throughout the history of the DRO, PIO offences, except, curiously, during the consultation period leading to the proposal to make the offence, when there were some 2 to 3 highly publicised such incidents reported as taking place in London, were splashed all over the Evening Standard. In fact, you'd be forgiven for thinking there were more, because the same incidents tended to be repeated day in, day out, on successive days from when the incident was first reported. Next point, the government response noted that 1,990 of the 2,217 responses to the consultation paper, that is 90% of the total responses, which were against criminalising squatters, were in support of the squash campaign. Therefore, the government stated that it decided to take a qualitative rather than a quantitative approach. The quote is, while we recognise that the statistical rate of response was therefore against taking any action to deal with squatting, it is important that the views of other individuals and organisations are reflected in the summary of responses, even if they are minority views. Well, it's very good to have this recognition of minority views taken into account by the government. And one would like to have minority views taken into account more often, but not in this particular way. Please remember, everybody, when you are responding to a consultation paper, do not identify yourself with a campaign, because your views will not be taken into account if you do. So, the offence came into force on the 1st of September 2012, and it's attached at the end of your handout. I'm going to make 3 main points about it. First of all, it's retrospective. That's section 144, subsection 7. It's retrospective in this way, that the offence can be committed by a squatter who was in occupation before the Act came into force and continues to be after the Act came into force. Secondly, the offence is committed by a trespasser, having entered as such, who knows or ought to know that he or she is a trespasser and is living in a residential building or intends to live there. That's section 1, and not being a former tenant or licensee, subsection 2. And lastly, building is defined as any structure or part of a structure, and residential is defined as designed or adapted for use as a place to live, and so adapted before the time of entry. So I'm just going to look at a couple of areas which the fence will not apply, as it seems to be. First relates to the definition of a building. It's confined to residential. So offices, warehouses, shops or other non-residential buildings are excluded from the offence. Also, what has to be adapted if the building is to be residential must be the building itself, and adaptations carried out by the trespassers are not themselves sufficient. So what's been called the situation of the bed in the shed, if the bed has been brought in by the trespassers or the squatters, that's not a situation which is covered by the offence. But bear in mind when I'm doing this that you're getting legal opinion for free. And what I'm doing is giving a legal opinion which has not so far been tested in the court. But this seems to me to be the case. Next, trespasser. The occupier must be in fact a trespasser and must know, or ought to know, that he or she is a trespasser. So when enforcing this offence, seems to me that a police officer needs to be reasonably sure that the person who is claiming that there is a trespass, the owner or person entitled to possession, is the owner or person entitled to possession, against whom there can be a trespass. The alleged trespasser may be excluded from the offence if he or she does not know that they are a trespasser because they believe they've been granted permission to occupy by someone entitled to do so. For example, a tenant or a subtenant, even an unlawful subtenant, it would seem to me, because that would be enough to found a belief. So the offence involves police in making difficult decisions about property rights in an area where documentation can be absent because there's no requirement for a tenancy agreement or for a licence to be in writing. So how has this all been working out in practice? Well, largely I'm going to pass that over to Mike, but I thought I'd just tell you about one case in Hove Crown Court last October, and in that case, a Section 144 defendant was acquitted on appeal from the Magistrates' Court, although it's not known the precise basis for the acquittal. The appellant or defendant took 2 points. First of all, the building was a former office and storage room, therefore it was not residential. Secondly, when the police arrived, the defendant had glued himself to his fellow defendants in the loft. And the argument there was, so they couldn't be said to have been living there, but who would live there like that? This took place on the 3rd of September of 2012, i.e. 2013, sorry, no, I did mean 2012, i.e. 3 days after the provision had come into force. So that was, I think, the first arrest, and that was resolved. And in fact, it was that date lent support to the defence that this was a protest rather than a living situation. Just 3 more comments about what's happened since enactment. First of all, both the Metropolitan Police and the Crown Prosecution Service have produced guidance on arrest and charging practice for the offence, and they both make clear that the police have a discretion not to arrest. Second, in March of this year, Squash issued a report that showed of 33 arrests which had taken place since the provision came into force. There had been 10 convictions and 3 prison sentences, and none involved squatters having displaced people from their homes. So the avowed purpose of bringing this in was shown not to have been relevant by the history so far. And lastly, there have been calls from members of Parliament and commercial property owners for the law to be extended to commercial property, which was an option been raised in the initial consultation. It's not known whether the government does have any such plans, and their legislative time is running out. But this is a watch this space issue, for there may be more. Thank you.
Thank you. Mike from ASS.
Yeah, thanks, David. You got to cover the good stuff, the history, and yeah, I want to start a bit by how ASS tried to deal with the new law when it came in, to give some kind of background. Partly, I think, because of the effects of the previous legislation, we had in the back of our minds a belief that somehow we were going to get around this, because I grew up with the 1977 Criminal Law Act as being the basis for how we defended ourselves. So I thought, well, that couldn't have been that bad. With the when interim possession orders came in 1994, they didn't really work that well. We managed to get around them fairly quickly. So the new law came in, and we thought there's clearly human rights arguments that we will manage to dig up and fight this off. Partly because we found that in Holland, where a similar criminalisation had been brought in, human rights legislation was used to effectively challenge it by saying people did have the right to go to court if they had in order to show whether or not they were trespassers. They couldn't just be decided on the doorstep by police. We've not managed to get there. We're still trying, so what we then did was, we spoke to David. We went through trying to work out exactly what it would and wouldn't cover and how we were going to argue it. We tend not to have these arguments in court. We tend to have them on the doorstep with the police, and so we tried to work out arguments, preferably in writing, because a lot of squatters, English is not their first language, or it's easier to have something that's in writing that you can show to police. One thing that wasn't said about ASS, as well as the Squatters Handbook, which is probably known to lots of squatters, although maybe not the new generation, because these things change. What's probably better known was the legal warning that was accepted by police as being like having garlic on your doorstep. It said, okay, we can't do anything. They got the legal warning. In fact, police have been known to say, you can't be squatters, you haven't got the legal warning up, therefore we can do what we want. On the other hand, it has worked in cases where it shouldn't have worked, by people who are simply occupying a patch of land without any, without even fencing it off, sticking one of these up, most of the time it would get the police to back off, even though legally it probably wouldn't have worked. So what we had to do was to adapt it, and so for example we came up with this one, simple one, which is this property is not residential, so it's okay, and quoting the relevant legislation. We did a slightly more specialised one which says this pub is not a residential property because a lot of pubs were getting squatted, and because there had actually been mention in the discussion in Parliament that warehouses and pubs were not meant to be included. So we quoted that as well. On the other hand, we tried to have a template, a cut and paste template that had all the things saying it's not residential, I'm not a trespasser, I'm not living here, I'm not planning to live here, and trying to have the backup for those arguments. So to go through let's start with some of the positive stuff. We have, as David said, there were 3 arrests in Brighton, 2 people got off at the first hearing, 1 got off on appeal. The only reason he didn't get off the first time round was that the police claims that he had said something about living or intending to live there, which he clearly hadn't. So that was the main basis of the appeal. But otherwise, there've recently been a couple of really useful successes, not in courts but on the streets, of people having protests and having legal warnings prepared saying, we are not living here, we are here protesting about homelessness, protesting about this property being sold off by the council. It's been good for publicity. What we've not tested is how long it would remain a protest and us not living there or intending to live there. So that's maybe one that we'll eventually have to go to court to see. A lot of people came to ASS when the new law came in and said, oh, I want to be a test case, I want to be a test case. And it's not, being a test case takes up a lot of your life, and most squatters are already very mobile, are moving around, hard to keep track of, and have to get on with their lives and have to sort out their housing at very irregular intervals, making legal challenges quite difficult. So anyway, that's worked, and we've not heard of any police arguing against that. In terms of people being tenants, we have heard but never got evidence of a Roma family in North London who were accused of being squatters. Police forced them out. Now, obviously this comes on the back of the propaganda behind the legislation was predominantly about Roma families in North London supposedly squatting people's houses while they were at proms. Clearly this wasn't true, but it's been very difficult to get evidence. We do also, we know of one successful case where it was fairly simply argued with the police, no, this woman is clearly a subtenant, and needed a bit of backup, but not too much. With police are, as usual, making it up as they go along. In London, there have been, it's patchy. Some police will make the decision themselves and will go in and will decide to get rid of the squatters. That's nothing new. Before this act came into force, constantly police decided they were going to get rid of the squatters. They would find whatever excuse. If they managed to force entry, they would then, or if not, they would threaten to arrest people for a list of hypothetical things that they had absolutely no evidence for. normally criminal damage, burglary, abstracting electricity, and if they manage to get in, they would threaten to arrest everybody unless they leave now. It's the new law is working similarly in some areas. The police add it to their list of these are things that we will arrest you for, even if it's clearly not appropriate. In some places outside London, in Manchester, we know police were going round places that are investigating places that they decided were squats and trying to find landlords to stand up and say, yes, these people are trespassers. And similarly, I think in Bristol, their police are particularly anti-squatter. But generally, yes, it's policing of this law seems not to be so proactive. The other arguments, in terms of residential, as I said, we created a special legal warning for pubs, saying this is a pub, it's non-residential, Parliament didn't intend it to be included. One of the first arrests that we heard directly about were 3 people who were arrested in a pub. They were accused of actually living in the upstairs flat above the pub, and the definition does refer to building or part of building or part of structure, and certainly at least one of them was convicted on that basis. We didn't see enough of the actual evidence to be able to work out. We didn't think it's the conviction should have happened, but we weren't involved enough to respond properly. But generally, police are backing off. Owners are backing off if the place is non-residential. As you said, obviously it shouldn't be such an issue. I mean, but one issue is that more and more people are squatting in what is clearly less appropriate places to live. So some people who are together can take over non-residential property and make it really nice to live in. A lot of people are getting forced into bigger and bigger groups, taking over places where they're not staying for very long, and it's not a good way of living. And to some extent, the government is using things like that to say, oh, well, this is terrible. This is why we must now criminalise squatting in non-residential property. Clearly, it's it was squatting in residential property was what made the most sense, especially as, I mean, not to go on too much about the propaganda, but the vast majority of squatting in this country has been in large-scale empty properties that are being decanted by council for redevelopment, that have been emptied for regeneration that has not yet happened, and it's that that's been criminalised, and it's that clearly makes the most sense. People requisitioning empty property that's designed to live in and living in it. But to get back to what has actually happened, that's the comparatively positive stuff. As I say, the arrests and convictions, yes, we know of those people in the pub. The first that got a lot of publicity were people in a flat in Pimlico, the landlord to a housing association who hadn't called the police, who were quite happy to carry on the usual old-fashioned process of when they were actually going to do something with the flat, they go to court. But unfortunately, the police went round there because somebody had jumped bail and realised what was going on and arrested them And yes, we've not heard any arguments about discretion. About what they thought about their discretion as to whether to arrest. They seem to have decided that they did have to arrest, or maybe they just thought that, oh, if someone's on bail, we don't like these people, we will do something about it. Now the other things that we have seen most directly, well, as I said, yeah, lots of people are squatting in places that are less appropriate. People are choosing, well, people are more likely to live in other insecure forms of accommodation, either on the streets as so-called guardians who we argue are tenants. Well, I guess anyone with legal knowledge would argue are tenants, but their contracts claim that they're not, and they have very few rights. Their property, their rooms can be entered and inspected. They can be removed with very, very little notice. But yeah, I think more importantly, people are living on the streets. We know that in the past, squats would have been opened in winter time for people that would be housing a lot more people, or people would be doing it for themselves. A lot of street homeless people, rather than actually squat, do what's called skippering, which means you just go into a building, you spend the night there, and then you leave. The difference being that if you're squatting, you've actually secured the place and you are looking after it. Not actually heard of whether the police are considering skipping. I mean, it certainly would be covered by Section 144, skippering as well. It didn't come up in any of the discussions. One thing we do know is that a homeless person died sleeping in the cold outside an empty building. The first reports in the paper said the police had said to him that if he went back into the building, he would be arrested under Section 144. Later reports seem to be a bit more vague, and it's just the police said they would arrest him if he broke in, which again, there's a possibility that they were talking about, well, it's now secured, so we would know that you caused criminal damage if we found you back in there. But it's certainly we took it to be the first known death through Section 144. And yes, in this cold weather, I'm sure there are other homeless people who are dying who maybe not because of Section 144, but maybe generally because squatting is not as available as it used to be in the past. People are more vulnerable. I think that goes through most of the particulars of Section 144 and how we thought they would affect things. We were hoping originally, we did talk to David about trying to have input into the codes of guidance, so that we could tighten things and make it clearer that there is discretion. There has been talk of saying to police, you do not have to arrest, and we can make arrangements to come down with our solicitor and be interviewed one at a time, which we've not managed to enforce. There's a lot of things like that having a good solicitor would probably make a lot of difference in arguing it. These are things that need to be tested out. But the reality is, yes, as I've said, it's used along with many other excuses by the police, and as well as that, a lot of things have been going backwards, becoming more difficult. One of the main issues that people have been facing apart from Section 144, is dealing with the High Court enforcement officers who used to be the sheriff. The High Court sheriffs, they are now, there's now hundreds of bailiff companies, many of which are also security companies, also everything else. They've basically got subcontracts from the sheriff to act as High Court enforcement officers. It used to be that claims for possession could be taken either in the county court or in the High Court, which changed when CPR came in. It was discouraged going to High Court and taking up the time of the more important judges, presumably. But when they did that, obviously the High Court enforcement officers felt that they might be losing out in custom. So the rules were changed, or it was made easier for a possession order in the county courts to be turned into a writ to be enforced by High Court enforcement officers. I know David's done a lot around enforcement and bailiffs in the past, but county court bailiffs tend to tell you when they're turning up, give notice, and generally make arrangements, whereas High Court enforcement officers will often turn up with no notice at odd times of the day or night, and there's been a lot of cases where it's not been clear that there has even been a writ. So in a way we've been going backwards and trying to fight those things which we need more help with. So basically, yes, apart from the new act, a lot of people are getting evicted very quickly, moving very rapidly. In some parts of London, it's the same properties that get squatted over and over again. Sometimes they're evicted, possibly with a writ of restitution, which again they don't know. So they've not even been to court. People squat somewhere, the owners claim that it's the same squatters or connected squatters, and they get a writ of restitution which is enforced without any notice to the people occupying. So they get a visit in the early hours of the morning, and if you're out, you have difficulty getting your stuff back. Obviously, we spend a lot of time explaining that it would be theft if people don't get their stuff back, but if it's our word against theirs, what's actually in the property, we're just squatters, and they're not. So, having said all that, the other good stuff, have I missed any? No. The other good things are that there are other groups working on this as well. There's now the Squatters Legal Network, which ASS has been going for nearly 40 years. We run an office and we're open 5 afternoons a week. Squatters Legal Network came into existence with a mobile phone, which we wouldn't even have thought of, being a bit old-fashioned. And are a bit more proactive, interactive in trying to get involved with people's cases. And also, ASS has been involved, has worked with housing solicitors a lot over the year. In fact, we've quite a few of us seem to have become housing solicitors, or through the process, we're now having to work a lot more with criminal solicitors, of whom most of us have got quite a lot of experience, but not so much around these issues. So it's been a learning experience that we need to develop with help.
Thank you very much. Well, that was a very clear exposition of the current state of the law, and of course the possibility that the law will be even more tightened up by making squatting in any sort of property a criminal offence. Questions, points, discussion? We've got about 10 minutes, half an hour. Yeah, go there.
Just a very simple question. I'm just interested in the number of squatters since the 1960s. Has it increased? Has it remained the same? Has it decreased?
So is the question, has there been an increase in squatting
Yes,
since
yes.
September 2012?
No, sorry,
No,
since the
since
60s.
Since the 60s?
Yeah.
Huh.
Up and down. There's
Yeah,
a big
because
surge in 69.
I think I don't know, probably the people from ASS are better have a shot at answering that first of all.
Well, can I say, ASS nearly folded at in the end of the 70s because the number of squatters went down massively because we won. There were thousands of people were squatting, and through squatting became tenants, set up short life housing co-ops, longer life housing co-ops. Everyone, all of the original collective of ASS, apart from one person, decided to pack it in and move on into other struggles. I mean, one thing what the people at ASS helped to organise an amnesty from the Greater London Council, who owned probably half of the social housing in London. Anyone squatting in a GLC property could turn that squat into a tenancy if they wanted. And you know, similarly, most councils had been turned round into encouraging short life housing co-ops, compulsorily purchasing properties that would have been, that were being left derelict by speculators. So yeah, in the 70s, it was a major movement that housed thousands of people, turned that housing into something more permanent, and defended social housing, certainly in central London, where it was under attack from office blocks. There's places in there's social housing in central London. Maybe a lot of it has now been bought by the tenants, but that certainly would not have been there if it had not been squatted. So it was a mass movement. I started squatting in 1980 when the first movement had come to an end, and they thought, oh, we've won. We don't need squatting's not needed anymore. So there was a new influx of people from abroad. There was a new influx to London of unemployed youth because of the policies of Thatcher, and there was a big build-up again in the 80s, including more politicised elements. Again, a lot of squatted social centres, a lot of activism from a new generation. And again, a lot of those people, managed to find ways of becoming more secure, and so it has gone up and down quite a few times through many phases. The thing now is that there's nowhere to go from squatting. So even though it's becoming a lot harder, we constantly have people coming back saying, I used to squat a long time ago, and it's got harder now, hasn't it? But I've got no choice anymore. So there's pressures both ways, but people are we're not good at numbers at the moment. It's really hard to tell, but there's certainly still thousands in London.
Can I add to that, just to generalise a little bit? I think a lot of squatters are now avoiding squatting in residential buildings. So the number of buildings squatted is probably decreased. Even the numbers of people still the same, the number of separate buildings is probably different. Because like Mike said, there's lots more squats with a big group of 20 plus people in the same space. And so that's something that's definitely changed. And if you look around at the buildings that are empty in London, arguably there's fewer empty buildings now than there were 20 or 30 years ago, just because of the way property price speculation has worked. There's areas of London where maybe they didn't used to be desirable areas, and now they're more desirable. And there's been a lot of development, a lot of gentrification, and people can rent those buildings out for a lot of money, and in some cases they're doing that, whereas maybe in the past they would have less rent for them.
How many thousand flats are empty on the Haldane estate?
Well, they start demolishing then.
Oh, right.
Yeah.
Oh, well, so,
But yeah, they've been left empty for the last 3 years or longer.
Also, David said to a friend of mine at the eviction the other day that they're busier than they've ever been.
Yeah.
I think the basic answer to your question, it has fluctuated over the years. But I'm just going to add, because there is a page on this in Squatting the Real Story, and I'm going to hold up the graph that they did, and you can see just how useful a graph it is, because it looks like a whale. And what it actually shows is that it rises and rises and rises till about 1977, which of course is the Criminal Law Act, and then it drops, and then it starts rising again. And I think that's the pattern. Housing crisis, squatting goes up. You have law brought in, squatting goes down. But then it starts to creep up again. There's more housing crisis until you get another measure, or the crisis diminishes. The government estimated 20,000 in, I suppose, England in the consultation paper. But Lord knows where they got that from, because they said in the consultation paper when they first issued it that they had very little information about squatting, and in fact to find out more was part of the purposes of the consultation. So there you are. By its very nature, it's very difficult to make an estimate. It's going to be interesting to see whether squatting starts to increase from now on because of the housing crisis that we are now in. Although there, again, one of the reasons for the more obvious growth in the 1970s was the amount of blocks of empty property because of a major compulsory purchase acquisitions or redevelopment which hadn't been gone ahead. And of course the authorities have run out of money for years to do major compulsory purchase acquisitions. So that kind of block of empty property is not so much about as it was, which makes squatters less visible, but they still continue to squat in the empty property which is available. So I think those are probably the best answers that we can give to your question.
At the back there.
Can you elaborate a bit more on human rights arguments that were used to try and remove them from squats? Because is it just kind of a due process argument, or because I think the European Court of Human Rights has said that homelessness isn't sort of human rights justification for squatting.
Yeah.
What kind of arguments were used?
Okay.
Did everyone hear that?
Yes, the human rights arguments in relation to defending eviction proceedings brought against squatters. Because this meeting is focusing on the criminal law, but just on that, the case of Kay in the UK, which Liz mentioned when she was introducing me, what that held at European court level was that Article 8 of the European Convention on Human Rights, which is the right to respect private and family, private life and the family and the home, was directly applicable to possession proceedings, and that, although there have been a series of cases, it wasn't until the 2000s that this came up as an issue, and the European Court was dealing with it. It might strike you as a surprise that it took that amount of time, because one of the reasons why it came up as an issue was because landlords and then governments argued that Article 8 didn't apply to possession proceedings. They only applied to give right to respect to people who were lawfully occupying their homes, and not when proceedings for possession were brought against them.
what happened as a result of 2-3 cases of European Court of Human Rights, which culminated in K and the UK, was that the UK House of Lords, as it then was, Supreme Court now, decided in 2010 that Article 8 was again directly applicable in UK possession law. And that meant that the courts could decide as a matter of fact, and the court decided what the facts were, and then applied Article 8 to the facts in deciding whether the possession order was to be made or not. And that meant that the court was engaged in the exercise of deciding whether it was proportional for the possession order to be made. And the reason why I was involved in that was because Article 8 is a qualified right. And what that means is that the right can be breached if, for certain reasons set out in Article 8, amongst which are national security and the protection of the rights and freedoms of others, outweigh the right to respect for home in the circumstances. And the right and freedom for others, in the case of possession claim, was the right of the landlord to possession. So what the court is deciding is, does it cause the occupier more harm to the evicted than it causes harm to the landlord for a possession order to be refused? Now, I know this is a rather long answer to your question, but this is the process which leads us to applying those principles to squatters, because what the European Court and the UK courts, before it got up to Europe, was dealing with was the Lambeth-Rushcroft Road cases, where the people were not actually squatters. Well, they were people who had entered as part of short life housing agreements, which various bodies, housing associations and cooperatives, had entered into with the London Borough of Lambeth, it was in that case, back in the early 1980s. And Mike actually touched on this when he was speaking. What did happen as a result, partly, of the squatting movement, was that authorities became more inclined to enter into those sorts of arrangements, because it meant they used property which otherwise would have been empty, would have been squatted. A lot of people who did enter into those kind of arrangements had been or might well have become squatters. But it was not a squatting case. But the principle, the proportionality principle, does apply to cases that are brought against trespassers. Now, when the UK Supreme Court applied the Article 8 principle to possession claims, they said, but it's going to be rare cases in which the right to possession of the landlord is going to be trumped by the needs of the squatter, because the squatter's a trespasser. And believe me, folks, those of you who are not property lawyers, there is no lower status existing in UK property law than a trespasser. You are at the bottom of the status pile there. So that's what they said. Two points are: one, the argument can be made in between Pinnock and my retirement, I've raised the argument on several occasions on behalf of people who write. And it could lead to a negotiated agreement which gave time or on one or two occasions the actual withdrawal of the claim. That's one thing. The second thing is, in spite of what was said about it being rare, even for those who had a right to have arthur exercise in their favour, it has happened that courts have dismissed claims brought against trespassers on Article 8 grounds, even though the Court of Appeal has reiterated again in the course of last year it's not only going to be rare, it's going to be even rarer that Article 8 can be used for a successful defence in a squatting case. So I think that's where we are on human rights and defending possession claims. And I'm sorry that was a long answer to that question, something like a lecture. But you did ask.
I'm aware that there are two hands, and I'm going to take them, and I don't want to prolong this. And you'll have worked out that David and I have very similar practices and have worked very closely together. But I just wonder, the police are a public authority.
Yeah.
They have to abide by the Human Rights Act.
Mm-hmm.
If they turn up at a long-standing squat,
Mm-hmm.
where the residents say, this is my home, and that's a perfectly reasonable argument, there's every reason to believe that it is, they didn't just come in yesterday. Is there not an argument that can then be raised in the criminal process that the police then have to conduct a balancing act between, on the one hand, knowing that these people have committed a criminal offence under Section 144, but on the other hand, bearing in mind that a decision to arrest them, and you did make the point, Mike, that arresting is different to charging, a decision to arrest them is an interference with their right to respect for their home and under Article 8, and therefore have to conduct a balancing act. I'd like to see a police constable struggle with that one. They have to do those sorts of balancing acts when they turn up at demonstrations. They have to balance Article 10 of forms of criminal acts are being committed. I'm anxious about not getting quite so legal, and I do know that there are hands up, but I just sort of throw that in, and maybe you'll come back to it when you respond to a couple of the other questions. Sister at the front in the third row.
Yeah,
here.
one's been answered. Don't worry.
Okay.
Answered, thank you.
Natalie towards the back, and then sister just in front of Natalie.
I was wondering whether any of you could comment on the Heathrow Road of Scots, and which I don't know if you know about it, particularly like Scotland, that they as a community had unified, and they had greenhouses and were growing things that were also doing community.
I'm not sure I'm hearing all this.
Sorry.
The Row Heathrow case, which became Malik.
And basically, it seemed, although the Court of Appeal rejected it, it seemed that they were trying to make an alternative Article 8 argument as well, that it was also kind of a community-based right.
Mm-hmm.
And I think that's a really interesting direction for that to go into, but also I think it does potentially draw in a bad picture of like good squatters and bad squatters.
Mm-hmm.
But I think that is an interesting way that the law could potentially grow, and I was wondering about your opinion on that.
Yeah.
We get involved with?
No. So that was an example of an unsuccessful raising of the Article 8. But it shows the sort of circumstances in which the defence could be raised, because that was a community garden as well as being part of the protest, and certainly all that does go into the argument. In fact, when we were arguing squatting cases back in the 1970s, arguing the community benefit of the squat as part of the process of getting the judge more on the occupier's side was something that was done. We got this legal argument, but you can exercise your judicial approach in our favour
judge with a much clearer conscience because you're allowing these people to carry on providing services to the community. So yes, that's a good example of the with the circumstance in which you can use the Article 8 defence.
I just wanted to know if the Land Registry Act 2002 conflicts in any way with the LASPO because of squatters who can claim adverse possession who will then register their interests to the land registry.
Okay, this is adverse possession, and for the purposes of this evening, I deliberately avoided touching on adverse possession, even though I think when people talk about squatters' rights, they are actually talking about adverse possession. But I think the problem that LASPO has created so far as squatters in residential properties claiming adverse possession is concerned is that it's going to make it less likely that people are going to be able to build up the at least 10 years worth of occupation which is required before they can even get to the point of asserting adverse possession rights. The whole thrust of the Land Registration Act 2002 was actually to make it extremely difficult for squatters on registered land to be able to complete the total 12-year period to enable them to say that. So this has made it even more difficult. And it did happen. I mean, I defended a number of cases on grounds that the squatter has acquired title by adverse possession, which again could lead to quite favourable settlements. Negotiated the concession of title to flats even. So adverse possession was very useful. It is actually a topic for an entire other evening should we ever get to it. So yeah, that's I think the result of this. But of course, this provision about residential land, adverse possession, covers all the land, and the Land Registration Act, the 2002 Act, doesn't apply to unregistered land. So there's still some scope there.
But we have heard of cases where the Land Registry have refused applications that would otherwise have succeeded on the basis that this is now a criminal offence.
What are those called? You know names?
No. They're not cases.
They're instances. Yeah.
Yes. We are not directly in contact with either of the ones we know of. We tried. And another thing is, one of the cases that we were hoping would be taken up as a human rights argument was someone who was in the process of an adverse possession claim, was actually appealing against a decision, and we thought it would be a good argument because she could have come under LASPO, under section 144. She had been in there for 12 years, brought up a family there, and unfortunately her appeal lost. There was a possession order against her, so LASPO became irrelevant, amongst other problems. In terms of arguing human rights on the doorstep, if people, we worried at first that, well, a lot of people worried who had been squatting places for a long time, that the police were just going to turn up and say, right, we can arrest you now. As I said, apart from some particular areas, it generally hasn't been like that, and our advice has been a bit more practical and less creating test cases of having an argument of why you actually have a licence.
Yeah.
Now, certainly you can say if you have been left alone for 10 years, then surely you've got some kind of licence. One of the things I probably should have said was licences is one of the things that police understand if there's something in writing. They don't understand if there isn't. We're really trying hard, which is the opposite of court. Most, 90% of county court judges, they understand it. They understand that, we invited the owner in, we showed him around, he left, and that was it. In court, we can say, well, surely that was a licence, whereas police are finding that harder to appreciate, and they want something in writing. We've been trying to write up legal background for our arguments on licences, and we still haven't managed to quite get that tested out properly. It's still rather vaguer than it should be at this stage.
Couple more questions?
Just to add on adverse possession of criminal offence, I'm going to confess that the case in which the judge in the High Court decided that if the occupation constituted a criminal offence, then you couldn't stack up your adverse possession time, was a case in which I appeared for the occupier, and it's Canterbury City Council and Wayne Smith, and it's about 3 or 4 years ago. We went to the Court of Appeal, and the Court of Appeal decided that we couldn't stack up adverse possession years because we were squatting on a public highway, and therefore you couldn't have possession of a public highway. So they then said, and we don't need to deal with this other fascinating point on whether your occupation being a criminal offence means you can't stack up your adverse possession years. So it remains a first instance decision that as whether there's going to be a case which the Court of Appeal does finally decide on, it remains to be seen. And I'd just like to finish on what you touched on. There's Human Rights Act defence to section 144. Of course, all legislative provisions have to be interpreted in compliance with the European Convention. And on that basis, yes, you could see that there could be a Human Rights Act defence, and indeed in the Metropolitan Police Guidance it says that the police have a responsibility to take into account individual circumstances. This includes the situation of the landlord, the nature of the offence, circumstances of the suspect, the needs of the investigation. The investigating officers may be presented in a situation subject to accounted by children or be otherwise deemed vulnerable. So in their guidance, they are requested to look at the situation from what we would normally call a Human Rights Act perspective. But of course, neither you or I are criminal lawyers,
no.
So we don't know.
There's one or two in the audience, I can tell you.
that would stack up in criminal law terms if you've got an offence defined the way this one is.
Right, that was David finishing. Anyone got any burning questions? Or shall we finish? Yes, over there.
Can I make a comment?
Please do.
I'm involved in the Squatters Legal Network, and if there are any criminal lawyers, in fact any lawyers in this room or people with a bit of legal knowledge who'd like to help us, we need help. We've heard today about what the law actually says. Oh yeah, police should take human rights into consideration. Bailiffs and high court enforcement officers should take human rights and people's vulnerability into consideration. But they're breaking the law all the time and they're getting away with it. And we get phone calls and meet people who are still squatting, who are having problems, where the police or other people done things unlawfully against them, and we need help to actually challenge this stuff. And there's a limit to what we can do as a group of amateur volunteers and things that we think if we had more lawyers on board helping us, just the difference between us sending a letter of complaint to the police and it coming from the solicitor's office, for example. So if anyone here is interested in helping out, finding out a bit more about what Scottish Legal Network or ASS do, we've got some leaflets down here, grab one as well, or come and chat to one of us. Right, thank you.
Thank you. So, volunteers pleased to help with the Squatters Legal Network. We do hope that those of you who are not members of the Haldane Society will think about joining us. As I say, you can get more information on our website, www.haldane.org. Please buy a copy of Socialist Lawyer, read it. We hope that will inspire you to join us. Our next lecture will be in this university, but I think over in the other building, on the 13th of February on human rights abuses by UK troops in Iraq and Afghanistan. The lecturer will be Phil Shiner, as I said at the beginning, and the last in this year's series will be on the 13th of March, and details of that lecture will be on the website. That's all the practical stuff that I need to say. It only remains to me to ask you to thank the speakers who've given up their time and have shown a real depth of knowledge and commitment to fighting for the underdog. And so will you please join me in the traditional way of thanking speakers. Thank you, David.